Here's another thing. Every law school that I'm aware of teaches a course called contracts. And amazingly, I think it's amazing to people who aren't lawyers at least, the students never read, never draft, never negotiate a contract in that class. Now everyone knows, including non-lawyers, that lawyers do those things all the time. And in fact, one of the main reasons to get a lawyer is if you need to carry out some transaction. For an individual, it might be purchase of a house. For a corporation, of course, it would be any of the major transactions that corporations engage in. But all we teach students in the traditional contracts class is how to litigate contracts. Well, why is this? I think it's because of what I said before. At the time Langdell developed this program, there was no empirical social science, and therefore people didn't know how to study a practice. They didn't know how to study what lawyers did when they engaged in the transactional work involving contracts. I, for example, was a transactional lawyer. I worked in the entertainment law field in New York City. I never once went into court. I never once litigated a case. We were, in fact, trying always to persuade our clients not to litigate because we wanted to retain them as corporate clients. And what I did exclusively was negotiate contracts and work out deals with opposing parties. For example, if I represented the producer, I would work out a contract with the director or with the screenwriter or with the actors. Roughly a third of legal practice is of this nature. That is to say, it's entirely transactional. But you wouldn't know that there was any such practice if you walked into a traditional law school and looked at the courses being taught. They're all litigation oriented. And that's, as I said, because Langdell didn't know how to study legal practice in a way that would make it a legitimate intellectual discipline. We know that now. We have entire disciplines. We have disciplines of sociology where we can look at the patterns of behavior that lawyers engage with one another. We have economics, and in fact there's a branch of economics called transaction cost economics that tells you exactly why modern contracts look the way they do and exactly what the sort of mechanisms or machinery is that is embodied in that contract. And this could be taught to law students, and it's a useful thing for them to know. But you have to get out of the traditional curriculum. Here's another problem with the traditional curriculum that makes it out of date. When Langdell developed this curriculum, the belief was that the common law was embedded in the traditions of the English people running back to time immemorial. That's why he could make this analogy between the principles of law and the undying principles of biology that Agassiz believed in. About 20 years after he developed this system, two British historians, Pollock and Maitland, did a study of the origins of common law. And what they discovered was that common law did not run back into time immemorial, that was in fact that claim was a propaganda campaign that was initiated by common lawyers in the 17th century when they were trying to oppose the Stuart monarchy. In fact, the common law was created by statute in the 12th century by Henry II, and his purpose in doing so was to impose legal uniformity on England. He got his crown as a result of a settlement in a civil war, and he was very anxious that England be at peace. At the time, every county, every shire, every hundred, every manor had its own law. And so what he wanted was a uniform law for all of England. Now, interestingly, he didn't care what the law was. All he cared was, first, that it was uniform, and second, that it was administered by royal judges so that he could get the fees, because legal fees were a primary source of income for a medieval monarch. And so what he did is he created these royal judges, and he said to them, you go invent the law. And that's the origin of the common law. That is to say, judge-made law. It's a grant of jurisdiction by statute, by Henry, to these judges to invent the law incrementally as they went along. It's called common law because the important thing was that it be common to the entire realm of England. I think most law students who are immersed in this common law as a kind of all-embracing reality don't even know where the term common law comes from. But that's where it comes from. So the idea was that, Pollock and Maitland's idea was that this was not something that was embedded in the immemorial traditions of England, but a specific policy that the royal regime developed in the 12th century for a specific purpose. Once you perceive that, the difference between common law and regulatory law begins to dissipate, and the mystique that we associate with common law, the idea that there's something essential to thinking like a lawyer that common law embodies, dissipates as well. And one recognizes that there are many different ways to think like a lawyer. There are regulatory lawyers and there are transactional lawyers as well as litigators. And what we should do is introduce law students to each of those modes of thought. And if there's some deep mystical regularity that combines them all, well, then that's something that should emerge from the study of each area, not something that should be imposed in advance on the basis of a legal system and an approach to law that was relevant 130 or 140 years ago and has been retained by American law schools and American law teachers, frankly, out of a sense of laziness and an unwillingness to reevaluate what it is that they're teaching in light of contemporary legal developments. One other thing that I think is very important is that in addition to changes in in law and in our thinking about law, have been changes in pedagogy. At the time Langdell developed his educational system, the theory of education was essentially the same as it was in ancient Greece, that you can find, for example, in Plato's Republic. And that is that education is a process of training the rational mind. That's why education traditionally began at the age of 7, because that was the age of rationality. And the thought was, well, once someone is rational, they can learn anything, and the only thing that matters is the sequencing. So, of course, you want to teach arithmetic before algebra and algebra before calculus, or you might want to teach medieval history before modern history. But the only sequencing depends on the internal content of the subject matter. We now, one other thing, I suppose, that's relevant is that Langdell and people at the time thought that the mind was a muscle. They thought that the more you exercise it, the stronger it gets, and that the educational process consisted of exercising one's mind. Well, we've had the 20th century since then. We've had John Dewey, we've had Piaget, we've had the development of progressive education, we've had the scientific understanding of how people learn. And what we've discovered is that mechanism and that model is completely false. The mind, of course, is not a muscle. It's a series of electrical connections. That's something Langdell couldn't have known because there was no electrical engineering at the time, but of course we know it now. And we know that learning occurs in a series of stages where the mind develops and achieves mastery. Piaget showed that children's minds are actually different and have different conceptual capabilities at different ages. Now, of course, our law students are adults. They're not developing either physically or mentally in the sense that Piaget meant, but they are certainly developing professionally. They're going from people who come in with basically no knowledge of law, in most cases, to people we graduate who we claim are qualified to actually practice law and represent clients in a 3-year period. So that's a lot of development. And what modern learning theory teaches us is that it comes in stages. Right now, what we do is we teach at the same level of specificity all 3 years. We start off with a definition of the field, whether that field is contracts or torts or securities or environmental law. We go down to a particular level of detail and we stop. So you take contracts in your first year, then typically you don't take contracts again, or torts in your first year, you don't take torts again, you go on to other subjects. Well, there are some problems with that. In the first place, it doesn't reflect learning theory. In the second place, it's a problem if you teach the same thing for 3 years. Essentially, in law school, traditional law school, we're teaching 3 years of second-year courses. So, not surprisingly, the students are terrified in the first year and bored by the third year.